dignitaries on the dais, off the dais, and the participants. Good evening to you. I expected that the function would begin sharp 6 p.m. as was held out to everybody. Anyway, the fall of the rains is a plea of alibi, which it should not happen. Because the founder, Dr. Dattopanta Thengdiji, he used to maintain the time in such a way. He was personally known to me, and he has stayed with me during the last leg of his life, a great intellectual. So much is not necessary to waste again. Coming to the topic, the doctrine of precedent. To know what is precedent, you have to know what are the sources of law. Most of you were present, I assume, when I spoke on previous occasions that there are 4 or 5 principal sources of law. The first one is conventional source, the legislation, the legislative process, which you call in English law we call as statutes. In Indian subcontinent, in colonial countries, we call them acts of parliament or acts of legislature. And the subordinate legislation or subsidiary legislation, or in Indian context, which Jain and Jain in administrative law calls as delegated legislation. So, legislature, be it state legislature, central legislature like the parliament, is the conventional source of law. You should have the clarity of what is source of law and what is law. A well is a source of water. Well is not water. Similarly, legislation is a source of law. Law being taken in Augustinian notion of law, or Caesar's notion of law, Aristotle's notions of law. Even that aspect is discussed in Plato's Republic, the Epicurean theories. In all these things, we can say law is nothing but a body of rules that regulates the conduct of people inter se, citizen and the crown. And sometimes in federal states like this, it may be states on the one side, state on the other side, state and the center on one side, state and states on the other side. Whatever it may be, Jalan Trading Company, etc., which Shirwari discusses in his 4th edition. So legislation is over. Number 2, custom is also source of law. Legislation arises from the state, from the legislature. The custom arises from the society. The government, as you know, Harold Lusky, the great professor of Manchester University, he said that state is formed because of wickedness of men. The society is formed because of goodness of men. That's how he describes in his famous books like ABC of Politics and Grammar of Politics, 2 famous books which he has written. He says these things which you can verify from the book. Then we go to the contract. Contract is also a source of law between the parties. What is contract? What is agreement? What is consideration? What is defeating the objects of law, defeating the policy, state policy, etc., which you have seen in best books like Farmston, Cheshire, from Farmston, Cheshire and Fifoot, and Chitty on contract of law, and Frederick Bullock and Mullah on contract, Indian contract. And if you see these things, you will have the broad idea, because that is whole contract is founded on the principle pacta sunt servanda, that what you have agreed to, that you should abide by. That is like, you should not go You should not withdraw from your words because other person has acted upon it. It is not like just estoppel. You have to make difference between estoppel, res judicata and precedent, which I will come later. So contract is also a source of law. If there is any dispute relating to the parties, we will say what is the arrangement between you. Because that arrangement will be governing the relation between the transaction between the two parties, and often Mr. G will say court cannot rewrite the contract, etc. Because contract is the law made by the parties themselves, because law permits it. Other three is over now. Then fourth one is the precedent, which is very larger topic. Much of time is spent in formalities and singing and worshipping, this, that, etc. Anyway, that's all right. The doctrine of precedent is a huge subject. Many books are there. Of them, two important books I am quoting. One is Precedent in English Law by Rupert Cross. He happens to be one of the great authors of law of evidence also. Rupert Cross' book on precedent in English law is followed in most of the colonial countries, more particularly in UK. Precedent in Rupert Cross means he is cited, like we quote Palkhiwala, Shirwai as authorities. We, with the English courts, quote Precedent in English Law by Rupert Cross. When we say precedent, before that I will say there is one more source of law, that is the opinio juris, opinion of great juries. In Muhammadan law you have seen the hadith, the way the great people in Islam conducted themselves, that becomes law. Or great people, when they opine something, that becomes law. In Indian context, if I want to give an example, when Nobel Prize was awarded to Mother Teresa, the question arose before the government of India whether it should be taxed or not, if at all, or it should be exempted from income tax. Income is defined under the Income Tax Act 1961. Earlier we had 1923 Act. The question arose before the government because the huge money came to the pocket of that saintly lady. Palkhiwala said, the question of exemption arises where income is taxable. If the income is not taxable, the question of exemption does not arise. That opinion was treated by the government, union government, as the opinio juris, opinion of juris. Juris opinions are taken as the law itself. Shirwai, H.M. Homi Shirwai, the great author of Constitutional Law of India, 3 volumes, 4th edition, he said nobody should edit the next edition for the period of 50 years. He did not permit that his book should be edited by anybody, at least for 50 years after his demise. Therefore, it has stopped at the 4th edition. Shirwai's constitutional law was being quoted when Shirwai was sitting in the court hall, and Shirwai's books will be quoted. This is the opinio juris. Palkhiwala, Kanga and Jamshedji Kanga and Palkhiwala on income tax. His handwritten book, because it had not yet gone to the press, these handwritten books were quoted before the income tax tribunal as the law. This is the source. This I am saying as opinio juris. Giving this brief, very brief, the bird's eye view of the sources of law. Now I am coming to the topic of precedent. As I said, in English context, in colonial countries context, the precedent in English law by Rupert Cross happens to be one of the finest treatises. And in Indian context, there is one book, of course, it's not that great, but you can just read it, by Professor Lakshmi Kanta, Precedent in Indian Law. You can just see it from your Google. The books which I am referring, the decisions which I am referring, just you can put, of course I know that my speech is being recorded so that I can be confronted if there is any mistake. What is this precedent? Precedent in Gautama Sutra, is called Purva Nirnaya. It has two meanings. One is res judicata, predicata. The doctrine of res judicata, predicata is one. It is already decided between you. Therefore, you cannot reopen it. Section 11 of the CPC. The doctrine of res judicata, restrictively enacted by the Parliament in 1862 CPC, 1908 CPC, and 1976 amendment, with a little broader outline, because constructive res judicata is also enacted in that. Parties are persons claiming under the parties. Decision on adjudication. Adjudication by the competent body, competent court or competent tribunal, competent authority. Whether res judicata applies to the judicial function or not is another aspect. There is another cuisine of this, estoppel. Section 114, 114 capital A, 115 of the Indian Evidence Act 1872. It stands on a different footing. It is not res judicata. It is something you make a person to believe certain thing. He acts upon that belief and alters his position to his detriment. Thereafter, the person who said something is not permitted to contradict the same. One illustration, the best illustration which is taken from Bombay High Court, is written in that 1872, the Evidence Act, Indian Evidence Act 1872, under section 115. A tells B that I am the owner of the property, I want to sell it to you. B enters into an agreement, and thereafter he did not want to execute the conveyance, therefore B went to the court. There A contended, when I entered into agreement, I was not the owner of the property, but I became owner subsequent to agreement. Court said the doctrine of estoppel is not founded on truth, it is founded on rules of reason and justice. Doctrine against prejudice, etc. There is doctrine of promissory estoppel. It is a bit different from estoppel. Estoppel operates in civil law, and estoppel operates to some extent in criminal law also. 1962 Supreme Court. Even res judicata applies to criminal proceedings. There are such judgments. Now, the doctrine of legitimate expectation is another aspect of that. In the light of these things, you should understand we should understand the doctrine of precedent. Precedent means what has already happened in a given circumstance that can be duplicated in the similar circumstance. For example, case is between A and B. A says, I am the divorced wife of B. We belong to the Islamic faith. I have no means of maintaining myself. I have no livelihood means. Therefore, my ex-husband should be directed to pay the maintenance. Section 125 of the erstwhile CRPC 1973. Duty to maintain. Thus, wife, children who are incapable of maintaining themselves. It only enacts whatever scriptures enacted. In Manusmriti there is a shloka which says, very often I quote it, I used to quote it when I was sitting on the family law side, Pita rakshati kaumare, bharta rakshati yavane, rakshanti sthavire putra. The next line may not be that important. The father looks after the child, the girl child, during her childhood, the father, Pita rakshati kaumare, kumari, kaumari. Bharta rakshati yavane, the husband looks after the lady during the youth, and rakshanti sthavire putra, during the evening of life, it is the son who looks after the mother. This is how that particular shloka runs in Manusmriti. If the question arises before the court, which court? It is only the constitutional courts which can lay down the precedent. That also you have to keep in your mind. The high courts under 226, 227, 228, 250. The Supreme Court under Article generally 141, 143 also. To some extent there is divergent opinion. Anyway, you can keep it as you want. What has been decided? Now the Supreme Court said in 1985-86, I don't remember the correct year, that famous Shawbanu judgment,
85.
where 1985 Supreme Court ACR, where the question was whether the word wife in section 125 of CRPC included a divorced wife, because Parliament has not employed the word divorced wife. It only says wife. The contention was, once the marriage is dissolved by divorce, by way of talaq, triple talaq, whatever talaq, then she ceases to be a wife, therefore no maintenance need be paid. In 1960s, Justice Dhawan of Allahabad High Court, 1963-64, I don't remember the correct date, he said divorced wife is also a wife for the purpose of section 125 of CRPC. The same law came to be reiterated or came to be laid down by the apex court, saying that divorced wife is also a wife. Now, what is the principle? Article 141 of the Constitution says, law declared by the Supreme Court binds everybody, whether they are parties or not. The difference is, if you are a party, you are bound by a decision. It is not because of precedent, but it is because of doctrine of res judicata predicata. Because you are a party to the proceeding, right or wrong, you are bound by that. You are not a party, still you are bound. Then decree in rem. You should differentiate between decree in rem, decree in personam, and the doctrine of precedent. Where in 4 jurisdictions, ordinarily the orders for decrees in rem are granted. One is admiralty jurisdiction, another is matrimonial jurisdiction, the third one is probate jurisdiction, and fourth one is insolvency jurisdiction. Section 41, 42, 43, 44 of Indian Evidence Act 1872. If a litigation is decided between A and B to the effect that A is the wife of B and B is the husband of wife, others are also bound by that, because it is a judgment in rem. There is slight difference between judgment in rem and the doctrine of precedent. In doctrine of precedent, a judgment is there. There is due adjudication. Principles are laid down in the judgment itself. Just take the best example we'll take. Whether the Constitution can be amended, then how amendment? What is the extent of amendment, permissible extent? Then you go to case 1 of the Bharati versus State of Kerala, 1973 Supreme Court, where the Justice Khanna, led by the other 6 members, held Constitution can be amended. Any part of the Constitution can be amended. The preamble is part of the Constitution, therefore it also can be amended under Article 368, subject to one rider, that amendment should not affect the basic structure of the Constitution, because you have a framework. What is basic structure? Again, is a big debate. We need not go into that. There are many books on doctrine of basic structure. The Nation speaks by Parkiwala's article is there, Professor Pathak's article is there, Professor Upendra Bakshi's great article, Constitutional Quicksands of Kesavananda. So beautifully it is said. So, when we go to, since I have got very limited time, I was not the speaker was the Advocate General. he spoke and has gone now, leaving the responsibility to me. Anyway, he said that I should speak to you. Therefore, I am speaking to you. My mother used to tell me a short story. To get the work done, something has to be given. A boy used to go to neighboring house every day, a very poor family boy. He used to go asking for buttermilk. And there were people who had abundant buttermilk, but they did not want to part away free. They would ask them, tell me the story of Ramayana. The boy will say, there was Dasharatha king. He had 3 wives, Kausalya, Sumitri, Kaikeyi, and Kausalya's son is Rama. And the other Bharata, though he did not desire, Kaikeyi wanted Bharata to be crowned. The dispute cropped up, and Rama, Sita, Lakshmana went to forest for 14 years, and Bharata asked them to come, but they did not agree. After 14 years, they came back, and Rama was again installed in the position. This is Ramayana. And you would get the buttermilk. That way I am telling you, the doctrine of precedent. It's a very huge topic. I need 2-3 hours to speak on that. But anyway, now short period, there will be short interaction also. Therefore, the principle laid down in a given fact matrix by a court of competent jurisdiction, which is of general application to the realm, is called the ratio decidendi. When you are studying Doctrine of Precedent, few keywords you can keep in your mind. Ratio decidendi, ration, that is decision, principle decided. Then the obiter dicta. Then the passing observation. Then judgment silentio or per incuriam. These are the general parameters of this doctrine. Ratio decidendi means the principle that has been laid down in a given case. That is called the principle, the ratio, ration. Rupert Cross very beautifully discusses these aspects. Of course, in Salmon's jurisprudence you will find it. Law and legal reasoning by Julius Stone. He discusses this pattern on jurisprudence, also discusses it. Many books are there. Lloyd's jurisprudence is there. Many books are there. Why it becomes important? Why it becomes important? It becomes important because you want to tie the hands of the God. What are these principles? You all know man's nature, which Leviathan author Thomas Hobbes, whom Salmon's jurisprudence refers. In Leviathan he says man is a rascal by nature. Even in the evolutionary process, the elements of rascality have not completely subsided because they are part of bone, blood and flesh. And Ralph Waldo Emerson, the great American thinker, said man is a rascal 2000 years ago. Maybe he was referring to pre-Christian era. And today, he is a rascal. Only difference is 2000 years ago, he was illiterate rascal. Today, he is literate rascal. So, when power is held by the rascals, the so-called sober men run the risk of being abused. That should not happen. Therefore, throughout the evolutionary process of man and the society, the care is taken by the right-thinking section of the society to ensure that the principles are laid down based on which the disputes are resolved. Otherwise, our state would become a forest, and monkey will claim that it is the king and it would lay down the policy for all of us. A monkey cannot decide affairs of the forest. Therefore, the principles are laid down. All laws in legislative process, I say, the legislators are not sarvajñas. They are not sarvashaktas. They are not sarvantaryamis either. They cannot comprehend what all situations would emerge in a given case. One famous case I will tell you, that is Head-on's case, which Salmon discusses in his 12th edition, Fitzgerald's edition. In Head-on's case, the law was that every ship which carries the sheep, flock of sheep, will have a cover around it. And this particular vessel did not have one. Because of the tidal action in the Irish Sea, all sheep were washed away. The cargo owner brought an action against the owner of the ship, saying, had he covered his vessel, my sheep would have been protected. Then the court said, the object was not to protect against tidal action, but to protect the sheep from catching the contagious diseases from the sheep being carried in other ships. So the principle came to be laid down, saying a statute cannot be used for the alien purpose. For the purpose for which it is not made, you cannot make use of. This principle becomes the ratio decidendi. What is the point? Suppose the question arises as to the validity of Hindu marriage in southern India, northern India, eastern India and western India. We go to Mitakshara, generally in southern India. I assume, I read some judgments also which says Mitakshara is applicable to state of Orissa also, barring one particular part. When we go to marriage, what are the essentials of marriage? The Hindu Marriage Act does not tell you what are the essentials. Vivaha Homa, Saptapadi, tying of Mangal Sutra, and the darshan of Arundhati Nakshatra. These were under Shastric law held to be the requirements of a valid marriage, Hindu marriage. Of course, law has evolved, it is not static, it is changing, law has to change depending upon the change in the social circumstances. Law and social change is another big topic which you will read. The Wolfgang Friedman, there are at least two books, how very beautifully they have been explained. Law in a Changing Society by Wolfgang Friedman. He discusses how law changes in Europe. There is law and social change by Professor Bhatt, the former Vice Chancellor of Karnataka Law University, who is the best author of 2-3 books here. Wonderful books they have written. The stress is, what is the principle laid down in a given decision? Amongst Hindus, I say Vivaha Homa, tying of Mangala Sutra, Saptapadi, Arundhati Nakshatra Darshan. If you go to Gautama Sutra, you will find that. History of Dharma Shastra by P.V. Kane discusses this aspect of the matter. Now, the question arises. Suppose if two Hindus exchange the garland in front of the family deity, in the presence of the people, especially relatives, friends, kith and kin, does it amount to a valid marriage? Then gradually, whether tying of Mangal Sutra is essential, if other procedures are not, we do not follow RN form of marriage at all. There are many marriages we have seen. Duncan C. Direct on Law of Marriages in India, a wonderful book of Paras Diwan. You have seen Mullah Mains, and these are, they also have discussed about that. The question is, the principle laid down in a particular case, which would be of universal application, in the same given fact matrix is called ratio decidendi. And principle can be laid down only by the constitutional courts, not by other courts, nor by other tribunals. Where there are tribunals, branches, various, for example, central administrative tribunals, state administrative tribunals. You can't say, in one case you have decided like this, therefore you should decide this case also. Similar way, you will say it not because of the doctrine of precedent, but because of doctrine of parity or equality. The parity is different, the principle of stare decisis is different. This you should have. Sometimes, how to know what is the principle laid out? How are you going to decide? If one judge decides, it becomes very easy to find out. Wambach's test, which someone says, inversion test. He will give A, B, C, D fact matrix. A is removed with B and C whether the proposition would exist. B is removed whether with A and C the proposition would survive. C is removed with A and B fact matrix, the proposition will remain. This is called inversion test. You will feed something and see whether the same proposition stands. Then that becomes the precedent. First test is the inversion test or Professor Wambach's test. Got the point? The problem may arise when a decision is rendered by plurality of judges. If all judges have decided together, there is only one decision, we have no difficulty. All are agreed, therefore there is unanimity. This is the principle that has been laid down. There are 13 judges, there are 9, 10 judgments. How are you going to decide which is the precedent, which is the ratio decidendi? It becomes very difficult. Many tests. There is Dr. Upendra Bakshi's test also. I will not spend more time on that because you will have we have question answer session also. In Keshavananda Bharati, 13 judges decided. It was so difficult for the 13 judges to decide what was decided in Keshavananda. Chief Justice Sikri skipped off his lunch. He asked his steno to prepare the particular principles which have been laid down in case 1. If you see that reported judgment, out of 13 judges, 9 judges alone have signed the judgment. 4 have not signed it at all. They did not agree with the propositions which Sikri has given in the last part of the judgment. They did not agree. 9 judges agreed. Then the question is, therefore Shirvai said, constitute a bench of 3 judges to decide what is decided by 13 judges. Churning out the ratio decidendi is not a small thing. It becomes very difficult. What the point? Then I was saying about that Hindu marriage case. Question is the validity of the Hindu marriage. There the court will discuss what is the marriage principle amongst Muslims, nikah, muta marriage, marriage for one sexual intercourse, marriage for a day, marriage for a night, children begotten or legitimate children. 5G's outlines of Muhammadan law, Mullah's Muhammadan, Muslims, Muhammadan law. They discuss about this. Suppose in a Hindu marriage case, something is said about the Muslim marriage, Parsi marriage, Christian marriage. That was not the issue. Therefore, that becomes arbiter dicta. Got the point? Arbiter dicta is something, it is opinion of the court on the points that were not required for adjudication of the case at hand. The case related to Hindu marriage. You spoke about the Muslim marriage, Christian marriage, Parsi marriage. Parties were not Parsis. There was no issue relating to this. but still Supreme Court, Honorable, the highest court of the country will say something. In Australia, High Court is the highest court of Australia. In England, House of Lords was now the Supreme Court itself. Okay? The highest court of the country says something on points that were not essential for adjudication of the case at hand. That becomes arbiter dicta. Amongst Muslims, the tying of Mangal Sutra is not necessary. Suppose we hold that way. That becomes arbiter dicta. What is the status of arbiter dicta? On this, opinion is divided. Rupert Cross is of the firm opinion, arbiter dicta is a destitute of presidential value. The courts need not follow it. But in India, there are judgments which say, which Basu discusses under Article 141 of the Constitution. D.D. Basu, Dr. D.D. Basu has discussed about it under Article 141. He says, arbiter dicta of the Supreme Court is entitled to highest respect. I may have highest respect for Mr. Bose, but I may not agree with him. With that highest respect, does it mean I will say one sentence, I have great respect, greater respect, greatest respect for this opinion, but I will not follow it. There are some judgments. There is another set of judgments which say that even arbiter dicta binds the courts. Other set of judgments. There is one very important judgment. Barkatullah versus Rudramurti. You can see it in your Google 95, 96 judgment of Supreme Court, where the three judgments headed by Justice Rajendra Babu said, Article 141 is not founded on doctrine of precedent at all. Because Article 141 of the Constitution says, law declared by the Supreme Court. It is not founded on doctrine of this. That's the lone judgment which I have seen in the constitutional law by D.D. Basu, M.V. Paili, and by Sirwai. A.B. Datta's, Mr. Arvind Datta's, A.P. Datta's commentary also I saw. He has not said anything about it. That's the lone voice of the Supreme Court. But Supreme Court, the Article 141 says, law declared by the Supreme Court. It does not say, law repeatedly declared by the Supreme Court. One single judgment may become the law. Although Aristotle said, one sparrow makes not the summer, which Shakespeare quoted in one of his works, I do not remember, it may be in Hamlet or the Adonis and Venus, I do not remember. But one single judgment of the apex court becomes the law. But then we are going to the precedent which suffers from the vice of subsilentio. Per incuriam. Suppose a judgment is rendered by the law laying down court. I am using the word law laying down court because High Court and the Supreme Court alone will lay down the law. There is no corresponding article to 141 so far as the High Courts are concerned. But courts have said under 215, 226, 227, 228 of the Constitution, the law declared by the High Court will be binding upon the people in that particular state, in its jurisdiction. When Bombay High Court in Mithu versus State of Bombay, Bombay High Court has struck down section 309, suicide, where attempt to suicide was an offence under IPC. These are offences. Maybe Brother Behra will be able to say that. I don't have much exposure to criminal law except that outlines of criminal law by Kenny's outlines, Sweet and Maxwell's publication, etc. and Maxwell, Glanville Williams, except that I have not read any law on criminal side. Therefore, there it was struck down. Many people used to travel to borders of Maharashtra and used to try for committing suicide. If they remain alive, if the attempt becomes abortive, they are punishable. Attempt to suicide is an offence, but commission of suicide is not, because the person who commits perpetrator is not available for being tried and punished at all. People used to travel to Maharashtra, where it was a safe place to attempt to commit suicide, because they had the fear in the event the suicide does not happen, we should not be prosecuted. So the law laid down by the High Court is confined to its territory. Then from that we have moved. We were taught in the law school by Professor Sheshadri, Professor Vishweshraya. They had taught me that law laid down by a court, High Court, is persuasive when it comes to other high courts. When it comes to other High Court, it is persuasive. I need not agree with full bench judgment of Madras High Court. Orissa High Court may not decide that. The other High Courts may, no. We only use a sentence. We respectfully disagree with the views of Madras High Court. We may not give reasons also. Then little difference is brought about by judgment of the apex court in Kusum Ingot versus so and so, where the Honorable Supreme Court said, you can look into that. Apasayat may be knowing that Kusum Ingot versus so and so, I think 2094, or I do not exactly remember, where it said, where one High Court judges central legislation, then its judgment is ordinarily binding upon other High Courts. So the idea of persuasiveness is, to a great extent, can you get that, which is that judgment?
Which was the state of Punjab.
The state of Punjab. The Kusum Ingot is a very famous judgment. On that, there is one view of Justice Mr. Fani Nariman. He said that offends the principle of federalism. Every state High Court is entitled to decide the matter in its own way, and it is not bound by the decisions of the other High Courts. There are such judgments. There is another problem now. Suppose I render a judgment without noticing Brother Behara's judgment on a particular point. He has already decided what should happen in a given fact matrix, and that judgment I do not notice, or it is not brought to my notice. We will generally, judges are very, very wise people in a way. We will always say, the counsel for the petitioner did not bring this decision to my notice, as if it is only the duty of the bar and judge need not know any judgment, any law, etc. Anyway, whether he brings to my notice or not, whether I notice it or not, my judgment in variance with the judgment of Justice, Honorable Justice Behra, Brother Judge Behra, is a per incuriam decision. A single judge of a High Court cannot disagree. He can disagree, but the procedure is he has to refer it to the Honorable Chief Justice, saying, there is already this view, but I do not agree with this view. Therefore, constitute a larger bench that will resolve. I say X, Mr. Behra says Y. The difference now is X or Y, or it may be Z also, we don't know. The larger bench will decide that. Got the point? This has happened even in the Supreme Court. What is fee? What is tax? What is essential religious practice? On this point, there are many aspects, but only two I am giving, because Mr. Nariman wrote in 1992 Indian Bar Review, the mounting inconsistency in the Supreme Court. The heading of that article, Indian Bar Review article, is there. Mr. Panda might have seen that article, I do not know, where Nariman said the mounting inconsistency in the Supreme Court. Because Supreme Court, unlike in America, Supreme Court, all the judges of the Supreme Court will sit together. There is a famous book, 9 Scorpions. judges in the US Supreme Court, each judge was called as a scorpion. I do not know whether you all call judges as snakes. Anyway, nobody has at least openly said it in court. Would have been very happy had anyone said about that. There they sit together and they lay down the law. There are dissenting opinions. Then we go by majority opinion. Dissenting opinion is there. Different opinion is there. Concurrent opinion is there. The consensual opinion is there. That again is a bigger topic. Again is a bigger topic. If you go on chanting the songs and the introduction of all guests present in the hall and starting the function after 30-40 minutes over after the given time, all that cannot be done. It should be indoor meeting. It should begin with a sharp time. Only relevant things should be spoken. Then it becomes meaningful. Otherwise, it will be a theatre, cinema theatre, where you will be entertained without etiquette. That if you enjoy is all right, but that is not the object of this session. Object of this session is written in the invitation card. Invitation card is an invitation to you, but mandate to the speaker. The speaker has to comply with the mandate, because it is an open assurance to the people that I am speaking like this today. Justice Krishna Dikshit is speaking. I should go. I should hear. I will not agree with him, but I will hear his voice. With that many people come. If I go on saying something else on Natya Shastra, I can, but that is not the mandate. Okay, then with this, to which part we should, I said judgment sub silentio. Suppose I render a judgment without noticing Odisha Irrigation Act, without adverting to particular provision in the Odisha Education Act 1969, the Odisha Urban Development Authorities Act 1982, I do not adhere to important provision. The English judges and English jurists like Jeremy Bentham, Holland, they say it is a judgment sub silentio. It binds the parties till it is set aside by the higher court, or in review or appeal, revision, as the case may be. But it does not have precedential value. It cannot be cited to bind the hands of the judges. What the point? If a judgment of court, just whereas judgment I ignore, then it becomes judgment per incurium. What's the point? Then I covered ratio decidendi, judgment sub silentio, per incurium, obiter dicta, now passing observation. I will take that Hindu marriage case now between A and B. The court says, amongst Muslims this is the procedure, amongst Parsis that is the procedure, amongst Jehovah Witness this is the procedure, amongst Jews it is the procedure. Now I will say, in America, there can be marriage between two men or two women. Is it the part of the dispute? Muslim law I can understand because we have Muslims. Parsi law, yes, we have Parsis. There are Parsi marriages. Christians, yes, we understand. They are part of this country. Therefore, to some extent, what are the customs prevailing in that community? I may be justified by way of comparative jurisprudence. But if I travel beyond the frontiers of the country, I go to African continent and decide how in Tanzania the marriages are performed. That becomes a passing observation. What is a passing observation? There are two judgments. One is of Rajasthan High Court, and another is by Bombay High Court. One famous judgment by Justice M.C. Chagla, the great Chief Justice of Bombay High Court. His autobiography, Roses in December. One of the best books which you will see that. So this is the bird's eye view. It is a very small little bird's eye view. It is not the owl's eyes view. Owl is it is not the view of ostrich. It is the eye view of tiniest of the birds which I see when I go for morning walk in my quarters, in the lawn of my quarters. Very tiny. They are so tiny, I get confused. Is it an insect or a bird? That bird's eye view I have put forth before you. Thank you for your patience.